you will have in your hand the traps in the question as well as guesswork, which will help you to get extra marks in the next test. I'll try to keep the video as brief as possible. So the easy questions I'll leave it to yourself and I'll discuss the rest of the questions. So if UPSC wants to confuse you, then they'll take two cases which are related to speaker itself, but they'll interchange the topic. It is not important that you remember each and every amendment, but there are certain amendments which you need to know. Another thing which I wanted to highlight about the schedules. We need to remember all the schedules and what does it mean. Remember the important parts. And usually whenever these terms like mandatory and compulsory comes, we have to be extra careful. So these are the traps which are usually given. Head of the house is chairman of Rajya Sabha, but the administrative head, whatever administrative tasks are there, who is heading that? It is Secretary General. Try to rank it within a single line as to which state came first and which state came second, though you are not able to remember the year of formation. Then try to know which union territory became a state. In this case, Himachal, Manipur, Meghalaya, okay, not Meghalaya, it was Manipur, Mizoram, Tripura and Goa. In this case, only 4 is correct. So you should know which union territory became state. So this is where UPSC confused. The answer was Article 14, because if you remember, Article 14 speaks of equality before law, and we had borrowed it from the British, and that provision in British was given by A.C. Dicey, where he speaks of rule of law, which means that there is absence of arbitrary exercise of power. So that is where it links to Article 14. So it was Article 14, but in that small period of time, we do not understand that. We are unable to think of it. President of India can dissolve Lok Sabha only, again, be extra careful. Do not blindly assume when you see only and all that it is wrong. Just be extra careful while reading. President of India can dissolve Lok Sabha only upon the advice of Council of Ministers. Be it NDB or be it any other international organizations like BRICS, BIMSTEC. So these are the things which we need to be aware, because these are asked recurrently in UPSC Prelims. See, the paper is largely static. Please do not expect such questions to appear in the actual UPSC exam. I am not telling this thing to scare you, because this is level 1 question. Hello everyone, welcome back to India for IAS. My name is Shreyas, and in this video I will be discussing Test-02, which is of Polity. So before we start discussing, there are a few things which I wanted to tell. I have divided this 100 questions by doing the tick mark. I have used green color to indicate easy questions. When I mean easy questions, these are level 1 and level 2 questions, and these questions are very well found in your standard book, which is Lakshmikant. So you can study that book well, and if you have studied that book well, you would be able to answer these questions easily. And I have used orange mark to indicate questions where there is some extra information, and this information along with being extra, it is important for an exam. So I will be indicating those questions with orange mark. And the questions which I have indicated with purple mark, these are the questions where I will teach you to some extent some tricks or tips that could be used to answer the question. So as this video will progress, I will be highlighting the important areas that we need to focus upon. I will be telling about the new content which you need to make note of. I will be telling you about the traps that are present in the polity questions, and also be talking about the guesswork trick. So the important areas many of you may already be aware of through PYQ analysis. Apart from that, whenever there is some new content and it is important, I request you to make a note down of it. Suppose if you have studied President chapter from Lakshmikant and you come across an important fact with respect to President, then please make a note of that fact in your President chapter itself, so that when you are revising the next time, it becomes easy for you. And there will be certain traps in the question. So wherever you find traps in the question, you take your question paper and you use a different ink to make note of those questions, so that you know what are the traps in the question when you solve the next test. Similarly, if there is some guesswork trick, at the top of the page you can write the question number, such as question number 4, then there is some sort of trick that could be applied. So you will have in your hand the traps in the question as well as guesswork, which will help you to get extra marks in the next test. So moving on, let us start our discussion. I will try to keep the video as brief as possible. So the easy questions I'll leave it to yourself and I'll discuss the rest of the questions. So with reference to money bill, see money bill under Article 110 is a very simple topic, but what I wanted to highlight here is, see, they have said Quixote Hollohan case provided that the decision of the speaker is final in the certification of money bill. This is true, but was it this case? See, Quixote Hollohan case is related to speaker but in anti-defection, not in the certification of money bill. So if UPSC wants to confuse you, then they'll take two cases which are related to speaker itself, but they'll interchange the topic. See, they are not bringing some case which is related to president or governor. They are bringing the same case which is related to speaker, but just that the matter has been interchanged. So do not get confused in these questions. Similarly, Aadhaar bill was passed by money bill. If you have not made a note of it, please make a note of it. But Aadhaar bill by default is not supposed to fall under money bill. But still Aadhaar bill was passed as money bill and this was subjected to widespread criticism. This is a fact, but this shouldn't have happened. It was one of the cases of over exercise of power by the executive. Similarly, with reference to President of India, see, this is also an easy question. Constitution mentions about the grounds for the impeachment of president. UPSC has recurrently asked this term that what is there in the constitution, what is not there. Constitution mentions, constitution defines. So these are the things that come in UPSC PYQs. Constitution mentions, in other case it will tell constitution defines, or in other case they might tell constitution speaks about the grounds of removal of a certain office. So in certain cases it is true, in certain cases it is not true. In general, constitution speaks in a very concise way about most of the things, but there are certain grounds or certain things that are mentioned in the constitution and we need to note those things. And in most of the other cases, the constitution doesn't define or mention those things. So here in this case, constitution does speak, it does mention about the impeachment of the president, that he could be removed for violation of constitution. Now that is only one word that is mentioned in the constitution. So what other things that we need to study when we are reading this? Along with the impeachment of president, what about the other officers? Does the constitution speak about the impeachment of governor? No. Does the constitution speak about the grounds of impeachment of a Supreme Court or High Court judge? Yes, there are two terms, insolvent and unsound mind. So these are the things that we need to know. For Supreme Court judge and for president, yes, it is mentioned. For governor, it is not mentioned. So when you are studying a certain topic, like here, in this case, president, try to link it to governor, try to link it to speaker, try to link it to Supreme Court judge. So you will develop a comprehensive understanding of the topic. Moving ahead, with reference to amendment acts, which of the following statements is not correct? In this case, I want to highlight about the important amendments. See, they are given various amendments here. It is not important that you remember each and every amendment, but there are certain amendments which you need to know. First amendment, 7th amendment, 42nd, 44th, 86th, then others like 52nd, anti-defection, 61, voting age. So you need to be aware of these amendments. Also amendments like 24, 25 where 31C was added. So these amendments you need to know. Usually they will ask the amendment which is related to a very important topic. So moving ahead, another thing in this question that I wanted to highlight, which of the following best reflects the principle of due process of law? India initially followed procedure established by law, but then due process of law was added by Supreme Court by highlighting and expanding Article 21. So due process of law we have taken from the American Constitution. So in these cases, which of the following relates to due process of law? So in this case, the answer was, it guarantees that laws shall be applied fairly and justly. Now this is the most appropriate answer in this case, but due process of law also includes this statement that it promotes the principle of natural justice. Principle of natural justice means whoever is the deciding authority, they shall listen to both the sides and not just one side before taking a decision or giving a judgment. So this was asked in one of the PYQs, and to a surprise, when I was studying due process of law, I studied both the sentences telling that due process of law means principle of natural justice and the law should be applied fairly and justly. but in the UPSC PYQ, when I was attending in the exam, this was one of the options and this was one of the options, and we had to choose among one of them. So in both this case, the most appropriate answer was upholding the principle of natural justice, and this was the UPSC answer in that case. So when UPSC does this, we have to choose the most appropriate answer among them. Another thing which I wanted to highlight about the schedules, we need to remember all the schedules and what does it mean. Remember the important parts. From part 1 to part 25, there are certain important parts, part 1, 2, 3, 4, 5, 6, then 8, 9, 10, then 14, then 15, then 18, then 20. These are important parts that we need to know, and important articles. Though UPSC has not asked directly questions on articles, it has asked or framed statements over schedules and parts, because these are lesser in number and could be easily remembered. So in this case, schedule 3 was correct. Schedule 4, allocation of seats in the Council of States. Council of States, in other words, is nothing but Rajya Sabha. But in hurry, when we are studying it, we might study that allocation of seats to the State Council, in the sense State Legislative Council. In hurry, we might do that mistake thinking that they are talking about State Legislative Council. No, they are talking about Rajya Sabha. We need to be careful. These things are easy. Schedule 7 speaks about this, and this is schedule 5. Question number 6. Since I have marked it in purple, let's see if some guesswork is possible. With reference to the British policies in India, Lex Loci Act of 1850 is related to. Suppose we do not know about this act, but when we have studied French Revolution, we know that we have heard terms like Lex Rex, that there was a transition from Rex Lex to Lex Rex, means law is the king. Here it was king is the law. There happened a transition after French Revolution that law is the king. So Lex Loci Act could be something that upholds the law, and it happened, it was British policy, and it happened in the year 1850. So British would try to do some policies or take some steps which would benefit them larger than the Indians. So lowering of age limit, recruitment in public service, this is one. Abolish slavery, we did not call it as slavery in official terms as to what it was there in India. So why would they do slavery from India? Because it will be beneficial for India. Rather than that, what are the other things that are available? Ban human sacrifice among tribals. These two options, they do not benefit British as such. So among the remaining options, right to inherit ancestral property by Christian converts. So here British is allowing to inherit the ancestral property despite getting converted, because the Hindu law told that if Hindus converted from Hinduism to Christianity, then they would lose their right to property. But British denied this. They said that even if you get converted, you still have your right over ancestral property. In simple words, they are promoting Christianity. So this is something that British would benefit themselves. So in this case, just by a mere intuition, we could have understood that British would do something that would benefit themselves. So with that, we would have got this answer correct. Moving on, question number 7. So the election of president happens through secret ballot. It's a easy thing, you can answer. But when you are studying this, what are the other things that needs to come to your mind? Election of president through secret ballot, okay. What about vice president? That is also through secret ballot. But what about the election of members of Rajya Sabha? That happens through open ballot. So if a MLA is voting in Rajya Sabha election against the party whip, does it lead to anti-defection? Does the anti-defection apply in that case? No, it doesn't apply. This was through one of the Supreme Court rulings. So these are the things that we need to study, and we need to connect things. Alright, moving on. With reference to distribution of legislative powers in India. So this is a simple question. I'll let you manage it. Similarly, even this is a simple question. Why Constitution is described as a living document? It has been asked so many times in PYQs. So here, see, our awareness about the things happening in the society will also help us or complement while solving UPSC questions. Playing of national anthem in cinema halls before the screening of movies is mandatory in India. Supreme Court of India issued a directive making it compulsory for all cinema halls. See the options. A is correct, R is wrong, A is wrong, R is correct, both are correct, and R is the reason for A. And there is another option telling that both A and R are wrong. See, both these statements are reinforcing one another. So, in simple words, either A and R both should be correct, or A and R both should be wrong. In this case, there is an option available that A and R both are wrong. So, someone who is going to Indian cinemas from 2018 to 2022, he would have noticed the difference that during 2017-18, during this timeline, this was mandatory, but then it was being removed. In recent times, for someone who has gone to cinema, he would notice that they are not playing the national anthem. So, even through this little bit of awareness, through our entertainment, we are able to answer this question. So, in this case, both A and this are wrong. And usually, whenever these terms like mandatory and compulsory comes, we have to be extra careful. So, these are the traps which are usually given. Similarly, assertion and reasoning. Indian Constitution is the lengthiest written constitution. The framers of Constitution aim to keep document clear to limit potential ambiguities and misinterpretation. See, usually we might study certain set of sentences in a standard book, but those sentences may not actually be present when we are solving the paper. In such case, we need to take a broader thinking. So, when we see Lakshmikant, we might see lengthiest written constitution. Why is it lengthy? Because there were legal luminaries, because India is a diverse country. These were the reasons that we studied. We may not have come across this thing. But is this true? This is true. And the question setter UPSC question setter would try to think in a positive way about our forefathers, and he would try to portray it in a very positive manner. So, we'll have to take these things as correct and think it in a very broad way. So, in this question, yes, A is correct and R is the reason for A. So, in these cases, choose the safe option. Do not do this mistake that you studied that constitution is lengthy just because India has diversity and because India had high legal luminaries. Do not keep that thing in mind and consider R to be wrong. Do not do that mistake. Think in a very broad way, because your broad way will be the safest option. Similarly, with reference to Indian Council Act of 1909, separate electorates were introduced. We are well aware of this fact. And income qualification for Muslim voters was kept lower than that for Hindus. See, when this extra word or when this important words like lower, higher, increasing, decreasing comes or mandatory comes, we need to be extra careful. For the first time, members were allowed to ask supplementary questions and given the right to move adjournment motions. See, this is static part. 1909 Act allowed them to ask supplementary questions but did not allow them to move adjournment motions. Now, this is static part. What about the statement 1? We know that separate electorates were introduced in 1909 Act for Muslim voters, but we did not know whether the income was kept lower than Hindus or higher than Hindus. So, how do you resolve this confusion? Just think from British perspective that if you yourself as British have implemented separate electorate for Muslim voters, so you would want them to vote in the separate electorate. So, in that case, if you keep the income lower than that of Hindus, then it will promote Muslims voting in the separate electorate. So, this is what they would do rather than keep it higher and contradict their own policy. In this case, this was correct. So, in this way, if you do this pattern of thinking, then you would have got this question correct. Similarly, which of the above rights are available to prisoners of India? Prisoners of India, let us look at the safe options. Right to speedy trial, it is available for everyone. Right to live with humane and good conditions, available for everyone. What about the other options? Right to freedom of speech and expression, even this is available for the prisoners. This we could have guessed. What about the others? Right to freedom of association and right to assemble peacefully. If we allowed the prisoners to do this, assemble peacefully, they could assemble and even act against the law enforcing authorities. So, this is something which we think that prisoners would not be allowed of. What about the others? Right to free legal aid and right to become a member of association. See, right to free legal aid. We know that free legal aid is not available for everyone. It is available for the vulnerable section as per the NALSA ruling. So, we are talking about prisoners in general. The prisoner could be a male prisoner, it could be a female prisoner, it could be an elderly prisoner, it could be a poor prisoner. So, all they are telling is right to speedy trial for prisoners. So, this right to free legal aid for prisoners. So, this becomes correct because prisoners in general will include all of this. But if they had mentioned right to free legal aid for male prisoner in general, then he would have not have got free legal aid. So we need to be very careful. So this is where the thinking broadly comes. And this is another fact which I wanted you to know, because in general, if we think, we might think that they might not be allowed association, but this is allowed. So 1, 2, 3, 4, 5, answer is 5. Consider the following statements about DPSP. Simple question, we'll manage. And question on FRBM Act. If you have studied about FRBM Act, this is a direct question, you would have answered it very easily. See, FRBM Act was enacted in the year 2003. Then NK Singh committee brought in changes in FRBM Act through their recommendation in 2016, and in the year 2018 there were amendments to FRBM Act. I do not want to go in deep, but I'll tell briefly what were the things that changed. So fiscal deficit was the indicator that we focused upon earlier. Then we changed from debt to GDP ratio after NK Singh recommendation. So debt to GDP ratio for central government should be 40% and for state government should be 20%. So cumulatively it should be 60%. And there were other provisions like escape clause that have been added. Escape clause means there are certain situations where we cannot maintain this debt to GDP ratio. So in that case we can give excuse. Escape clause could include natural calamity, agriculture failure, it could include war and these sort of things. Please have a brief look, have a broader outlook over those provisions which are there for the escape clause. There is no need to remember each and everything. If you understand it, it is more than enough. And another thing is Independent Fiscal Council, IFC, was been recommended, which is yet to be set up by the government. Moving on, which of the following best describes the concept of citizenship? So it is a question which you can manage by yourself, but here it is not a statement that has been picked in the book. They have tried to formulate a sentence to give meaning. So it is an interpretation based question. So concept of citizenship. Look at the one which is most appropriate. A shared cultural history, identity. Just because we are sharing cultural identity, no, that is not citizenship. A legal status that grants person residency rights. Just because we get residency rights, that doesn't mean citizenship, because you can even take visa and get residency rights for a certain period of time. A performative act of national identity. Performative act constantly negotiated, see, through participation in civic life. We want citizens to do this, but this is not the condition. Another is formal recognition, very important word, which provides us with legal and political rights, that too belonging to a sovereign state. So this is more appropriate compared to these things. So in every statement there will be that 1 to 2 word through which you can eliminate and get the right option. Similarly, Charter Act 1813, 33, 33, 53, these are things which you know. So I'll skip this question. Again, the next question is upon which of the following statements are related to Consolidated Sinking Fund. We know Consolidated Fund of India, we know Contingency Fund of India. So what is this Consolidated Sinking Fund? 14th Finance Commission. In Polity, like I said, where do they give the traps? They give traps here. They could give traps changing from, they could give traps where President is been replaced by Governor, where Parliament is been replaced by Central Government, and this is another area where they could give the number as wrong. It could be 15th Finance Commission replaced by another, or another replaced by 15th. So in this case, 14th Finance Commission recommended that all states should have sinking fund. The statement is correct, but it was not 14th Finance Commission. So this is where they give the traps. It was 12th. It is managed by Reserve Bank of India. Seems okay because debt is managed by Reserve Bank of India. The fund can be used for redemption of loans only. See, though only is there in this, here it is telling the sinking fund. If you had studied Consolidated Sinking Fund, you would know this is correct. Though there is only, in this case it is not wrong. As per 2018 amendment, FRBM Act, government shall contribute at least 1.5%. So like I said again, the trap is in numbers. It is not 1.5. So in this case, the answer would be only 2. Whenever you see numbers in any topic, when you are solving questions, please give extra attention and double check if it's right or wrong. Another thing, consider following page with reference to first cabinet of independent India. So who were the members of first cabinet? Who were the members of interim government? Once India got independence, there were several committees that were formed. So who headed each of those committees? We need to be sure of. it is an important topic, and that is why I am stressing you to study. Moving on, which of the following features are borrowed from Australian Constitution? Which of the following features are borrowed from UK, borrowed from Canada, borrowed from Japan? So these things we need to study, and this is very well given in a tabular column in Lakshmikant. Who among the following can be made a member of parliamentary committee? Here there was a little bit of difference in the answer that I saw. Who among the following can be made a member of parliamentary committee? Comptroller and Auditor General? No, he cannot be a member. Railway Minister? Yes. See, even in parliamentary committees, there are certain committees where the minister or the member of the government cannot be a member of, and there are certain committees where he can be. So you need to know which are those committees where the minister can be a member. So here they have asked generally as to who can be member of parliamentary committees. So Railway Minister, yes. Attorney General, yes. Why? Because it is one of the parliamentary privilege under Article 105. Parliamentary privileges extends to Attorney General. It does not extend to President or Vice President. So in my view, Vice President cannot be a member of parliamentary committee because he is neither a member of the parliament nor does he have parliamentary privilege to enjoy. So who among the following? The answer according to me is 2 and 3. But there is alternative view that many of parliamentary committee members are appointed by the chairman of Rajya Sabha. So Vice President can appoint the members to many parliamentary committees, but he himself cannot be a member. Which of the following events may lead to dissolution of Council of Ministers? Easy question. And what I want to tell is which of the following events may lead to the dissolution. So they are telling may lead to the dissolution. So if it's may, you will have to include if the annual union budget is rejected by the Lok Sabha. So be very much aware of even the minute of minute words when it is polity. Which of the following parts of the Constitution provides for equality among the citizens of India? In such questions, take a very broad view. Which of the following provides for equality among the citizens? You know Article 14, which comes under fundamental rights. You know the answer for this. Election with universal adult franchise, you are providing equality under Article 326. You have the equality, you have equal rights to contest and you have equal rights to vote. Another one is DPSP of state policy. So the concept of Article 38 of providing social justice, or 39 providing free legal aid, or equal remuneration to even women along with men. So these are provisions which point towards the equality. So 1, 2, 3, all three are correct. So in these questions, try to be as broad as possible. Question number 24, which of the following statements with respect to quorum in the legislative bodies are correct? See, we know what quorum is, but the confusion comes, is quorum mentioned in the Constitution or is it mentioned in the conduct of rules of Lok Sabha? This is where the confusion comes. So here I want you to make a note of the things which are there in the Constitution, not in the Constitution. Quorum is being mentioned in the Constitution and it has said that it has to be 10% of the members in the house, including the presiding officer. This is one thing. Another couple of facts which I wanted you to know is that there is a quorum for the parliamentary committees as well. Now this fact is not present in the routine books, so please make a note of this. And look at this statement, the Legislative Assembly of a state can by law decide the quorum required to constitute its meeting. So if you have to think, if we do not know this fact, then how do we think? See, not every state has the same number of members or same minimum or maximum members as given. There are certain states which have very less members, which are less than the minimum number of members for a state legislative assembly. See, certain states like Sikkim, Goa, they are very small and they have lesser members in the assembly. So there are chances that they could be given provisions like this, that they can make their own quorum through a law. So in that sense, if you are taught that in India there is asymmetry between the states, so certain states could be given certain special provisions. So in that sense, if we are taught, we would consider this as correct, and we knew statement 1 was correct. So we knew statement 1 and we considered statement 3 to be correct. So our option would be either and only 2 or all 3. So among this we could have done 50-50. Moving on. Which of the following statements is correct about Secretary General of Rajya Sabha? Secretary General is another important topic about which there is not much mentioned in Lakshmikant. So he or she is appointed by the presiding officer. Secretary General of Rajya Sabha is appointed by the Chairman of Rajya Sabha or the presiding officer of Rajya Sabha. See, look at this statement. He or she assists the presiding officer in conducting the proceedings of the House and giving them advice and expert. See, these are very generic statements. So you cannot tell these statements to be false unless and until you studied about it and you are very thorough of it. He or she is the custodian of records. Yes, this is also correct. Secretary General acts as the custodian. He or she maintains the records of the House. He or she is the administrative head of Rajya Sabha Secretariat. Do not confuse administrative head with House, head of the House. Head of the House is Chairman of Rajya Sabha, but the administrative head, whatever administrative tasks are there, who is heading that? It is Secretary General. So this is correct. Only one is wrong. So answer is 3. Similar thing will apply to Secretary General of Lok Sabha also. Consider the following statements. Leader of opposition in relation to either of the house has statutory backing. Yes, leader of opposition has a statutory backing. Where there are 2 or more parties in opposition to the government having the same numerical strength, then leader of opposition is chosen by lottery. Suppose we know one is correct, then it is not 2, it is not neither. So how do we choose between these 2 things? Let us see. When there are 2 or more parties in opposition in the government having the same numerical strength, we know that leader of opposition is the leader of the largest opposition party apart from the government. So there are 2 parties, both are opposition and they have equal numerical strength. So in that case, how do we do this? Now just recall from your memory about the lottery. Try to recall from your memory that have you come across lottery to decide something in the parliament? If you have not come across it, then you can think this way that maybe the lottery provision was very earlier when there was British and so on. But in recent times, we do not resort to lottery for deciding anything. If you had thought in that way, then you would have considered this as wrong. Actually, the answer to this question is when there are 2 opposition parties with similar strength, it is the presiding officer who will decide who shall be the leader. So in case if you do not know about this, but you know that the chances of deciding it by lottery is very less, then you would have considered as wrong and got the answer as 1. So your way of thinking, your thinking pattern will also be decided by the content that you have studied. You should keep the content that you have studied in your mind as the reference point and then develop guesswork. So only if you have content can you make proper guesswork. Which of the following statements are correct with respect to Article 368? So these are simple things, but Article 368 you should know it very well. See, Constitution amendment could be done in 3 ways. One is simple majority where you do not need Article 368. Then when you are using Article 368, there are 2 types, special majority of the parliament and special majority of the parliament along with majority of more than half of the states of India. So what are the provisions for which simple majority is needed? What are the provisions for which special majority is needed? So these are the things that you need to know about. When you are amending the preamble, when you are amending the fundamental rights, when you are amending the DPSP, you need special majority of the parliament. But when you are amending the 5th schedule, 6th schedule, you need simple majority or simple majority is enough. But when there are certain provisions such as 7th schedule, when you are making changes to 7th schedule, you need special majority of the parliament as well as half of the majority of half of the states of India. Which of the following statements are correct regarding acquisition of citizenship? See here, like I mentioned, there could be a word play that is made. Parliament could be replaced by central government because when we study, we just accept it. So parliament, central government, though difficult to remember, we'll have to do this as to what are the areas where central government has the power and where parliament permission is needed. Like I said, parliament, central government, president, governor, they usually try to interchange. President could be interchanged with prime minister also or governor. Which of the following statements are correct with respect to Nari Shakti Vandan? So this was 106th Constitution Amendment which provided reservation for women in Lok Sabha and State Legislative Assembly. It has not provided for State Legislative Council and Rajya Sabha, though there was a committee, I believe it is Geeta Mukherjee committee, which suggested that women should be given reservation even in Rajya Sabha and State Legislative Councils, but that was not the case. This is a clearly current affair dominated topic, and this is very well present in the current affair magazine that you would consider to study. Moving on, Indian federalism is constitutionally asymmetric because of, see, Indian federalism is an asymmetric federalism. So you know this is a simple question and you will manage by yourself. This is another question which is interpretation based. At times UPSC will frame options to check your understanding of the subject. These two options had appeared in one of the PYQ, and this option has been framed by the paper setter. See, we know liberty, we know equality. Liberty without equality. We have liberty, but there is no equality. So what would happen? Supremacy of few over the many. Since there is no equality, there is chance for supremacy because there is liberty. Look at this, equality without liberty. People are equal, but they do not have liberty. When you do not have liberty, then there is no right to individual initiative. You cannot showcase what you want to do, though you have equality. So it would kill individual initiative. Even this is correct. 1 is correct, 2 is correct. And look at this, without fraternity. What is fraternity? It is a sense of brotherhood between the members of a country or even between countries. Without fraternity, if we had liberty and equality, could not become a natural course of things. It simply means that if there was no fraternity, liberty and equality, it wouldn't have been that natural. So if there was fraternity, then we would respect each other, so there would be some sort of equality. And if there was fraternity, we would not restrict others from their individual initiative, rather we would promote it. So it reinforces even liberty. So in this case all three are correct. So this is how you could have taken each word and thought with respect to other word as to what was possible and what was not possible. Moving on, question number 32. Okay. How many of the below requires special majority? See, there are different kinds of things. Like one is simple majority, you know what it means. Then there is special majority. This is special majority where 2/3 of members present and 50% of total strength. There is another thing called effective majority. Effective majority means majority of members present and it should be more than 50% of the total membership. This is effective majority. So in which of these following cases do we need special majority? Okay, what was the first option? To pass Rajya Sabha resolution to empower the parliament to make laws in the state list. Yes, it requires special majority. Resolution by the state legislature for creation or abolition of legislative council. Yes, it requires. Removal of vice president. Removal of vice president is through effective majority and not special majority. Removal of chief election commissioner, yes. So this is correct, this is correct, this is correct. Answer is 3. I believe the solution speaks about a different thing, so that is why I discuss this question. Removal of chairperson of Rajya Sabha, vice chairperson of Rajya Sabha, removal of speaker of Lok Sabha and deputy speaker of Lok Sabha. For all these 4 persons, if there is a removal that is needed, then we go for effective majority. And in case of removal of vice president, there is another special provision. First, there should be effective majority in Rajya Sabha. Only if Rajya Sabha initiates the motion for vice president removal can he be removed later by the Lok Sabha. The Lok Sabha by itself cannot initiate the motion because the Rajya Sabha enjoys certain special rights with respect to the Lok Sabha. There are around 5 rights and I hope you are aware of it. See, this is a easy question. Constituent Assembly declaring itself independent sovereign republic. So from which of it was taken? So it was from objective resolution of 1946. Similarly, preamble question. See, preamble related, I think there are 3 cases: Berubari Union, Keshavananda Bharati and LIC. So these 3 cases, what was the Supreme Court's judgment in each of these cases we should know, because preamble is an important topic. How many times was preamble amended? Even this we should be aware of. Again, citizenship topic, static topic, you will manage. Here I wanted to highlight, see, try to know the order of formation of each of the states. First there was Nagaland, then came the other northeastern states. So Maharashtra, Gujarat, Nagaland, then comes Manipur, then comes Sikkim, then comes other states. So try to know this order of formation. It is given in Lakshmikant, but try to rank it within a single line as to which state came first and which state came second. Though you are not able to remember the year of formation, then try to know which union territory became a state. In this case, Himachal, Manipur, Meghalaya. Okay, not Meghalaya. It was Manipur, Mizoram, Tripura, and Goa. In this case, only 4 is correct. So you should know which union territory became state. See, every year UPSC doesn't tend to ask these kind of questions, but once in 3 years, 4 years, it tries to go towards this basic to test your understanding. Because many people wouldn't have studied, and that is the time when UPSC will ask. Similarly, which of the following are directive principles of socialist principle? Constitution has not classified the DPSPs into socialist, Gandhian and liberal principles. It is we who have classified it, so it is more of a convention and it is not mentioned in the Constitution. So socialist principles, it was an easy question. Moving on, fundamental rights, fundamental duties. Okay, easy question. Committee on estimates. So here I wanted to highlight, see, parliamentary committees, we should know about those committees. 3 things, 3 important things. What is the work does the committee do? In most of the cases, the committee name itself will tell what is the work that it does. For example, committee on privileges, we'll see if there's breach of privilege or not. Similarly, questions have appeared on the strength of the committees. In each committee, there will be Lok Sabha, Rajya Sabha members. So how many Lok Sabha members, how many Rajya Sabha members? For example, in estimates committee, I remember it as 30-0. So from Lok Sabha there are 30 members, from Rajya Sabha there are 0 members. So this is the way we need to remember. And another one is special feature. Special feature as in the estimates committee can be traced to standing finance committee set up in 1921. So it was the then finance minister John Mathai who had suggested setting up of estimates committee. So these kind of special things, if there is any special thing with respect to a committee, then we need to know. If I have to elaborate this again, then committee on subordinate legislation, committee on, so these are the committees where the ministers are not allowed to become members. So special feature of it. So these things we need to be aware. Moving on, the rest of the things are simple, but parliamentary committees is an important topic. Please do not ignore this. This is another simple question picked up from a static source. 41. Okay. There is one thing which I wanted to highlight it. This is a easy question. What are the common features between British and Indian constitution? Rule of law, yes. Written, no. British has a oral constitution. Federal polity, no. British is a unitary. There is only one government. There is no center or state. There is only central government there. Single citizenship, yes, because since it's unitary, it will have single citizenship. And even India, despite being federal, has single citizenship. It is telling amendment of the constitution. Amendment of constitution is permitted both in British as well as Indian constitution. But the way of amending of constitution is different in both. British, they can do amendment to constitution, any part of the constitution, through simple majority. But in India, like I said earlier, simple majority, special majority of the states. There are 3 ways to do the constitution. So this question, there is a little bit of confusion, but UPSC wouldn't try to frame sentence in this way. See, British and Indian constitution both permit amendment of the constitution. So if it is only amendment of the constitution, the statement would be correct. But if it says way of amendment of constitution, then it would have been wrong. So in this case, answer would be 3. This is another question which I want to tell. See, doctrine of pith and substance, doctrine of colorable legislation. We can use these doctrines while writing mains answers. Suppose if there is a topic on Supreme Court, then we can mention one of the doctrines which it follows when we are speaking of the conclusion. But if we do not know about this was a question that needs to be skipped, because we do not study about these doctrines in detail. nor has the doctrines been asked in PYQs. So I wouldn't stress much on it. I'll move ahead. Constitutional amendments, important topic. Any easier question? Emergency provisions, Article 352, 356, 360, Article 365. We need to be aware of this. And when emergency provisions, to continue national emergency, what is the majority that is needed? To declare national emergency, to continue president rule, to declare declare president rule, to declare financial emergency, and there is no need to continue it. So these things we need to be aware of. Moving on, 44. See, which of the following are considered as amendment of the Constitution under Article 368? Like I said, you need to know for what provisions simple majority is enough and for what Article 368 is needed. Collective responsibility, simple question. Next, resolution, motion, simple question. Policy cut, economic cut, token cut. It's a basic simple question. And the question is this, though this is a memory question, this is not some area which we would focus upon much. See, we know that there are 22 official languages in the 8th schedule. But the Constitution Act amends the 8th schedule to include which of the following? See, this schedule has been amended 2 to 3 times, and each time there was certain set of languages that were added. So when we are studying, we need to think in certain way that when we are studying, we need to see the similarity between each of this. Bodo, Dongri, Maithili, Santali. Each of these languages are named after a tribe. So these are tribal languages. When we are studying, if we know that were all these tribal languages added to the same amendment, or was in a certain amendment there were 2 tribal languages and 2 non-tribal languages. So if we are studying and remembered in such sort of way, we would have remembered this, that all the tribal languages that are present in this 8th schedule, which are these 4 languages, were added together. So we would have gone for option 4, option D. I have told that way of remembering because it was asked in 2024 paper as far as I remember, and I remembered it in such a certain way that there was Konkani and 2 other languages which were added together. So I remembered that these 2 languages were clubbed with Konkani. So with that reference, I was able to get the correct option. Then which of the following statements are correct about the Constitution of India? Again, highlighting, you need to know the important parts of the Constitution. Here they have given the provision and the part. It is a simple question. Moving on. Again, here 7th schedule. In 7th schedule, the power of legislation is divided between the central list, state list and concurrent list. So what are the topics that come under state list and concurrent list and central list? We need to know this. By 42nd amendment, there were certain topics that were moved from state list to concurrent list. So if Parliament wants to legislate or move a subject from state list to concurrent list, can Parliament do it on its own, or how can state permit Parliament to do it? So these things you need to study. In this case, census is something that is in the union list. Moving on, which of the following statements regarding Committee on Privileges in Lok Sabha are correct? So it is a standing committee of Lok Sabha. If you see, this fact is not mentioned in Lakshmikant. Speaker of Lok Sabha refers to matters related to breach of privilege. This is a generic statement. Committee on Privileges can impose punishment on a member. Now, if you have studied, you would know that most of the committees of Parliament, in fact all the committees of Parliament, they are advisory. What they tell is not mandatory. So you would have known this, that if there was a breach of privilege, it would have advised the presiding officer to take action over the member. So if you studied that way, you would know this was a wrong option. And in general, whenever we speak of any organization such as international organization or group of countries combining together for a common purpose, in most of the cases they are advisory. In less cases are they mandatory. So if you remember the cases where it is mandatory, in rest of the cases we can very confidently assume that it is advisory. So in this way also we can reduce our dependence on memory and focus more upon the smart work. So if we knew 3 was wrong, we would have got answer 1 and 2 correct, though we did not know this, but this is a fact. This is another thing which I wanted to highlight. Article 14, Article 19 and Article 21. These are the 3 articles where UPSC would try to confuse you. Because Article 21, you know, it is very broad. So are 14 and 19. See, in this case, under which article of the Constitution of India did the Supreme Court recognize right to clean environment? Now, this is an easy question. It was under Article 21. But I remember in the year 2021, UPSC PYQ, during the actual exam, there was a question that was asked upon arbitrary power, absence of arbitrary power of the government. Under which article does it come? See, when we listen of absence of arbitrary power, we might think that Supreme Court doesn't let the government of the day to exercise it arbitrarily. So there were options like Article 14, Article 32 and 2 other articles. Now everyone knew it was not these 2 articles, but there were so much of confusion between Article 14 and 32. So this is where UPSC confused. The answer was Article 14, because if you remember, Article 14 speaks of equality before law, and we had borrowed it from the British, and that provision in British was given by A.C. Dicey, where he speaks of rule of law, which means that there is absence of arbitrary exercise of power. So that is where it links to Article 14. So it was Article 14, but in that small period of time, we do not understand that. We are unable to think of it. So most of us went for 32, but it was 14. So be careful about these 3 articles. What is the primary meaning of equal protection of law? Equality before law we have borrowed from UK, equal protection of law we have borrowed from US. See here, special privileges, no. Uniform laws for all citizens. If you make uniform law, then where is this? Even this is not the answer. See, here the confusion was between A and B, but carefully look at the options of A. Equal protection of law means the law needs to be applied equally for those who are equally placed. So you cannot do arbitrary discrimination. State cannot do arbitrary discrimination. This is the answer to the question. But look at option A, identical treatment in all circumstances. Suppose it was mentioned as identical treatment in identical circumstance, then even option A would be correct. So please be very careful, because when we see equal protection of law, we might study this, that identical treatment in identical circumstance, and we might consider A and move on to the next question. So do not do this mistake, read all options. Moving on, with reference to legislative procedure for finance bills, easy question, you will manage. Which of the following best captures essential function of a constitution? Again, it is an interpretation based question. And if you see in this interpretation based questions, many a times UPSC gives negative options in the 3 statements, and it will give 1 positive option. This has been done so that you are able to get the marks. UPSC has to give easy questions so that you are able to answer, and this is one type which falls under that. So again, governor versus president, scheduled and tribal areas. So under 5th schedule, there are so many areas where president has more power. In 6th schedule, governor has more powers. So you read it in detail. Which of the following statements are correct with respect to adoption of Indian Constitution? In this, there was a difference when I saw the solution. So I want to talk about this. Indian Constitution was adopted by the Constituent Assembly on 26 November 1949. This is correct. This date is correct. Also this date is correct. But why? 26 January was chosen as the date of enforcement to commemorate the adoption of Purna Swaraj. If you had studied about the adoption of Purna Swaraj in modern history or polity, you would know that Purna Swaraj, the idea was adopted in December 1929 and not in the year 1930. So there was a word play because of which the option got wrong. 26 January is commemorated because it was on 26 January that Purna Swaraj was declared publicly. So on a public platform, the leaders had said that they would aim for Purna Swaraj. Though Purna Swaraj adoption was on this date, but it was declared publicly on this date. That is why 26 January we had launched the constitution. So in this case, statement 1 is correct, statement 2 is false. Moving on, with reference to Indian Parliament, again president was a presiding officer, adjournment, Sunday, summoning, prorogation. So for which president is needed, for which speaker is needed, basics. Consider the following statements. In India, public health and sanitation are primarily the responsibility of state governments, which formulate their own policies and programs for healthcare delivery. Okay. Constitution of India places public health and sanitation under state list of the 7th schedule, empowering the states to legislate. See, if you see this, both statement 1 and 2 are reiterating each other. So, one advantage in this assertion reason type of question, if both are going in the same direction, that means both are correct or both are wrong. If you look at the options, there is no option telling both are wrong, so both are correct. Even if you did not know, then you could have made a smart guess. Again, jurisdiction of powers of Supreme Court of India. Okay. I think there was a difference in the solution. Supreme Court power of judicial review is not explicitly mentioned. 4 is eliminated. I think the answer given in the solution was 1 and 2, but Supreme Court has advisory jurisdiction where the President can seek opinion on legal or constitutional matters. So, if it is either legal or constitutional matter, then the President can approach Supreme Court for advice under Article 143. So, D is correct. Answer should have been 1, 2, 3. With reference to anti-defection law, okay, here you will have to be very careful. Like I said, whenever you are studying polity, whenever you are attempting polity questions, you need to see word by word, because even a small word can make difference in the answer. Legislator voting against party whip in a no confidence motion incurs disqualification. If automatically was taken out, then this statement would have been correct. Legislator voting against party whip in a no confidence motion incurs disqualification. Yes, he will incur, but it is not automatic. Because there was this word automatic, the statement is wrong, or else it would have been correct. Decision of the presiding officer is subject to judicial review. This you know. Similarly, this you will manage. Similarly, here I want to tell you, be very careful. They are talking about adoption of constitution, which is November 26th. If it mentioned enforcement of constitution, then it would be 26th Jan. So, if you had read it, if you took this as 26th Jan, you would have got the wrong answer. That is why I wanted to highlight. Again, during emergency, federal structure in India converts into unitary one. Okay. See, even in this question, in this assertion reasoning also, sometimes what happens, both the statements are correct. We just go with A or we just go that R is supporting A. So, in the part 1 of constitution, union of states is preferred, correct, or federation, yes. And during emergency, federal structure in India converts into unitary one. This is also correct without a formal amendment. But is this the reason for this? No. See, India is called Union of States because the states do not have the right to secede from India. They cannot leave India on their own. States do not have that freedom. That is why it is called Union of India. It is called Union of States. It is not because of any emergency provision. This has been forcefully inserted. Both the statements are correct, but the answer to this question is B. So, we will have to be careful. Usually, if statement 1 and statement 2 are not at all related to each other, then it is option B in such cases. But usually, even if statement 1 or statement 2 are somewhat related to each other, then the answer to that would be A, where R supports A. Reasoning supports assertion. Similarly, this is over the amendment, static topic. See, another trick I wanted to tell is, or rather a hint, whenever this match the following sort of question is given, see if any two options are interchanged. For example, amendment procedure of the constitution is been taken from South Africa. Method of election of president has been taken from Irish. Usually UPSC does this. Rather than giving some options which are not at all related to this, it will try to interchange, because if you are able to identify that, then it shows that you know this, you know, but you have studied Irish also, you have studied South Africa also. It is only because you have studied that you know that it has been interchanged. So, whenever you get these type of questions, please see if there is any interchange that is being done. Moving on. DPSP static question with respect to preventive detention. Okay. Person cannot exceed 3 years under any circumstance. Again, see, it will give, so these are the places where you will find trap. Preventive detention of a person cannot exceed 3 months under any circumstance. See, it will lean towards extreme things. So, this becomes wrong. There are cases where it can exceed 3 months. Constitution exempts detaining authority from disclosing such facts which are considered against the public interest to the detained person. See, what it said is correct, but is it mentioned in the constitution or is it not mentioned in the constitution? This is the confusion that we should get. We should not get confusion whether it will prioritize public interest or it will prioritize the interest of the detained person. Definitely it will prioritize public interest, but is it there in the constitution or not? This is what we wanted to make note of. Yes, it is there in the constitution. So please remember this, even though do not make a note of it. So again, Parliament has exclusive authority to make law on preventive detention. No, it doesn't have. Sorry, it does not have exclusive authority on all the subjects, but on these subjects it does have exclusive authority. This is correct. So like I said, here there is an extreme sentence. I remember while attempting the prelims paper, there was another extreme sentence such as, we know that in Lily Thomas case, if you are convicted for more than 2 years, then you lose your chance of contesting again. But there it was given that you lose a chance for contesting throughout your life. No, that is not the case. That was an extreme thing. If you are disqualified because you got imprisoned for 2 years, then you are not allowed to contest for the next 6 years only, but not for a dear lifetime. Moving on, right to freedom of religion, religious rights, Article 25-29, with reference to provisions related to official language of the Constitution. Again, I have highlighted it for some trick. Let's see what is that. Okay, look at this. We know what 8th schedule is. We know about the official languages. Just now we spoke of it. States can choose their official language only from the languages mentioned in the 8th schedule. Just think of it. There are 22 languages in the 8th schedule. What if there are substantial portion of people in many states who do not speak a language that is mentioned in the 8th schedule? So what about their rights? It is a very important right. It is a cultural right, and language in India is a very important cultural trait that people respect, and the government of today will have to respect those cultural traits, because language as such, it doesn't lead to conflict among the people such as a religion or caste. So we could have considered this as wrong. If more than 2 states agree Hindi language can be used for official communication among these states, this seems generic. Yes, there is no issue with this. Governor of state may direct any language to be officially recognized throughout the state. Is it the governor or is it the president? That is what I said. There are chances that president and governor could be interchanged. It is the president and not the governor. So the answer is only 2. Answer is only 2. Okay, again a static question. Moving on, like I said, again amendments are important. Here if we see, we could have solved this question just by amendments. See, addition of 10th schedule is 52nd, anti-defection. Reduction of voting age is 61st. Removal of right to property is 44. We ourselves got 44 greater, first 44, then 52, then 61. We would have got the answer, though we did not know the first sentence. Again, in this statement, what is that trick which we could have thought of? We know All India Forward Bloc was associated with this. We know that Indian National Congress led the Quit India movement. So we know the answer is not only one, but it could be either of these 3. Now look at the other 3 options. We know self-respect movement, and who led it? E.V. Ramaswamy Naikar, and he was a Dravida. So it could be something related to Dravida Kazhagam. And look at here, Assam. Though we are not sure, it may be that Assam and Assam agitation was related. So in this way, if we are taught, we would have gone for all 4. The answer in this question is all 4. So when we have to take a guess between 2 options, this is how we can think. Which are the fundamental rights which are only available to the citizens? I want you to make note of the rights which are only available to the citizens and not to foreigners. There are 5 rights. Article 15, 16, 19, 29 and 30. These 5 rights are available only for the citizens and not for the foreigners. Based on that, we could have answered this. Moving on. Which of the following statements are correct about constitutional amendment? I found some issue in the solution. Article 368 allows Parliament to amend any part of the Constitution. See, Article 368 allows the Parliament to amend any part of the Constitution, including fundamental rights. Article 368, if you only consider this much statement, then this is false. But when this thing is added, we get confused if it is correct. But we will have to consider this as false, because Article 368 allows Parliament to amend any part of the Constitution. No, it does not allow. Because Supreme Court, through its basic structure, has limited the amending power of the Parliament. Fundamental rights, yes, it can be amended, but not everything, because there is basic structure. So this becomes wrong. But if this sentence was directly copy pasted from a book, then this would have been correct, because they would have given an earlier reference that apart from basic structure, then they would have given this. So this person might have picked this question directly. So he had given the statement to be correct, but it's false. Judicial review, simple thing. Basic structure, introduced in Golaknath, no, Keshavananda Bharati, KB 1973. Moving on. Which of the following are features of Indian federal system? Here again trap was given is, see, federal, so it is not single citizenship. Bicameral, yes. Independent judiciary, yes. 2 and 3 are correct. But equal representation of states in Rajya Sabha. See, please be very careful. It is speaking of only federal. It is not asking whether symmetrical federal or asymmetrical federal. This is asymmetrical federalism, but it doesn't fall under general federal system feature. So the answer is only 2 and 3. Moving on, who served as the interim chairman of drafting committee? When I was seeing this question, even I was not aware of the exact person. But like I said, the things that you see in YouTube, the things that you discuss with your friends, even that could help you to solve. I saw one of the YouTube video long ago where the lawyer Sai Deepak, as you may know, he was commenting about B.N. Rao, that he was very much helpful in formulating of Indian Constitution. Rather he played a much important role or equivalent role to Ambedkar, is what he had said. So when I saw this, I got to know that the interim chairman, if not Ambedkar, then it could have been B.N. Rao. So in this way, I was able to answer the question. This was a fact. If you did not know this, it was better meant to be left rather than making random guesswork. So again, President of India has the authority to modify the list of scheduled tribes in a state after consultation with the governor. Okay. A community listed as scheduled tribe in one state automatically gets the same status in all other states. This is wrong. See, you might have heard that Jats are OBC in certain. Similar things apply to other OBC categories or SC or ST categories. So usually what happens in a state, if a given caste and they have good socio-economic indicators in a particular state, then in that state status. So it varies from state to state, which makes the, so if you knew this, you could have answered this, because first one we know, we are not aware of the second statement. Again, vote on account was used earlier, now it is not used. Basic things. Consolidated Fund of India, simple question. Following statements regarding finance bill. Okay. See, there was another glitch that I found in the solution, so I will be discussing this. Which of the following statements regarding the finance bill are correct? It is presented along with the financial statement and gives effect to government's tax proposals. Correct. Unlike the appropriation bill, Rajya Sabha can suggest amendments. This is correct. In the solution they have taken it as wrong, so I wanted to tell. See, but even this is wrong actually, because Rajya Sabha has the power to only suggest. It cannot make amendments, and Rajya Sabha has the power to suggest both in case of appropriation bill and finance bill. So here it is said, unlike appropriation bill, Rajya Sabha can suggest. No, even in appropriation bill, Rajya Sabha can suggest. So that is why only one is correct. But in solution they had given another reason, so that is why I wanted to discuss. With reference to adjournment and dissolution of Indian Parliament. Okay. Adjournment Sundays means the termination of a session without setting a date for next meeting, done by presiding officer. Correct. Dissolution of Lok Sabha ends its very existence, and all pending bills. See, here is the trap. In all pending bills do not lapse when Lok Sabha dissolves. There are certain bills, usually the bills which are related connected with Lok Sabha, those are the one which lap. For example, if Lok Sabha passes a bill and the bill goes to Rajya Sabha, or the bill is with Rajya Sabha, then it lapses. Rajya Sabha has passed a bill and the bill is pending with Lok Sabha, then it lapses. Whereas if Rajya Sabha has passed a bill but it has not been for Lok Sabha, then it does not lapse. Gone for the presidential assent, then it won't lapse. So all the pending bills will lapse. This becomes wrong. President of India can dissolve Lok Sabha only. Again, be extra careful. Do not blindly assume when you see only and all that it is wrong. Just be extra careful while reading. President of India can dissolve Lok Sabha only upon the advice of Council of Ministers. Yes, and has no discretionary power. See, when there is no clear majority that has been established by a particular party, then the president has the discretionary power to dissolve the Lok Sabha. So this is wrong. The answer to this question is only one. It was not present among the options, so I wanted to discuss. Moving on, simple question. UAPA Act permits the detention. This is 90 days and then it is extended to 120 days. A fact which I wanted you to remember. Government of India, diarchy, simple question. Preamble of Indian Constitution again. Okay. Conduct of census, collection of caste related data. Again, I will highlight something which is extreme. Census is conducted under entry 69. Make a note of this fact because this is entry 69. Though in this case there is number, this is an important fact and we should know this. So not every time we see a number will it be correct. Then Article 340 empowers President to appoint a commission to investigate conditions of this. This is also correct. Article 340, entry 69. Then the census commissioner can include caste related questions in the census questionnaire only after amendment. Amendment is not needed. There is good amount of flexibility that is provided for the census commissioner. So this is wrong. So 1 and 2 are correct. Please make a note of Article 340 as well as entry 69 of Union List because census is a topic in news. Statements regarding private members bill in the Indian Parliament. Private member bill can be introduced by any member of a parliament who is not a minister and its drafting is the responsibility of the concerned member. Okay, it is correct. Only one private member bill has been passed. Okay. Only one private member bill has been passed by parliament. See, only one, even if you did not know this fact, only one private member bill is very, very less. So anyway, you would have assumed it to be wrong. I think there are 12 or 14 private member bills that have been passed till now. But the last private member bill that was passed was in the year 1970. It is very fascinating to know that after 1970, there was no private member bill that was been passed. So like I said, in this case, again numbers given are wrong. So as far as I remember, when I spoke that numbers could be wrong, in these 4 questions, there was only one question where the number they had given was right. And in 3 questions, the number that they had given was wrong. So in all these 4 questions, if you had assumed that the numbers given are wrong, then you would have got 3 correct and 1 wrong. So that is 6 marks minus 0.66. You would have got 5.4 marks. But we never know, UPSC might change its pattern. So we will be taking guess at our own risk. Like I said, again important case laws. See, important case laws doesn't mean some recent law. Rather, these laws have been asked time and again, and these are very important. Like Anuradha Beshin with respect to internet access, or with respect to freedom of speech on internet, Shreya Singhal case. These laws we need to remember also because we need to substantiate our mains answer with these case laws. Okay, in the context of Supreme Court ruling, suppose if you do not know about this Supreme Court ruling or the power of Supreme Court under Article 142, this was a question that was meant to be skipped. But you had a little idea about Article 142, then see what we could have done. The doctrine omni majus is minus allows courts to set aside part of arbitrary award. Suppose we do not know what this is, but we know that under Article 142, courts can set aside part of an arbitrary award. So even if we did not know this, we knew Article 142 is something related to this, then we could have accepted this as correct. Similarly, Article 142 grants courts the power to grant relief even if it contradicts. See, sometimes if they want to make the statement wrong, they'll try to exaggerate over the sentence even if it contradicts. So in this case, it is wrong. So in this way, we could have taken a guess, because even under Article 142, court cannot contradict the Arbitration and Conciliation Act, because it is a statutory act and Supreme Court itself has said it. Like I said, important case laws. Then India's legal framework on refugees. India has dedicated law for refugees. India does not have. We use this thing in case studies, because in case studies, when there is some issue going in neighboring country and there is influx of refugees from India, and when they have given us a case study, we tell that India is not compared to the refugees, but India does it to promote the fraternity. So India's dedicated law for refugees, this is a knowledge question. Refugees in India are generally treated as category of foreigners or aliens. Since we have not accepted refugee convention, even this looks generic based upon that. Passport Act allows center to remove foreigners who enter without a valid visa. The only trap could have been whether is it Passport Act or whether it is some other act. In this case, it is correct. So the answer to this question is only one. See, like I said, in this question, when you see that center can remove foreigners who enter without a valid passport, this is a very generic sentence. Only thing is whether it is under this act or do we have any other dedicated act. So only that should have been the confusion. But in this case, this is a generic thing, and India has a dedicated law. That was a knowledge based thing. Likewise, like I said, if we know the order of formation of states, if we knew the order of formation of states as to which was formed first, Nagaland was formed first compared to all these states. So they are given the year 75, 63, 72, 87. So Nagaland means the first one. So 1963 was the earliest. So 2B, let us see at 2B. 2B, the only option we would have got, the option is correct. We need not remember each and every year that each of these states were formed, but we need to know the order. And if there is any good reason or good thing that we need to remember as to what was the reason for its formation, even that we can be aware of. Again, assertion question. Okay, simple question. Here I wanted to highlight, see, this is a current affairs question, or you can tell this is a question, static question related to IMF programs. In the last 5 years, twice has UPSC asked over the programs of IMF. IMF has so many facilities or arrangements with respect to lending. So in that sense, they have asked. So please see the synopsis. There are so many arrangements and facilities that through which IMF provides credit. There are certain facilities through which IMF provides credit to low income countries, and there are other mechanisms through which it provides to countries in general. So see here, if we had to do some guesswork without knowing any of this, what is that we could have done? Standby arrangement is part of general resource account. Okay. Rapid credit facility is part of poverty reduction and growth trust. Rapid credit, okay, something that is done rapidly. Resilience and sustainability provides concessional loans. Concessional is okay, but at market interest rate. Look at this. We cannot speak of first statement, but look at these two statements. Where do you see a little bit of issue? Resilience and sustainability. Sustainability means it should be sustainable. So it should be, interest rates should be low. And resilience, if the interest rate are at market interest rate, will it be sustainable or resilient to all the countries? No. So provides concessional loans at market interest rate. So if I had to take a guess among these three options, or if I had to disprove any one of these three options, then I would have considered 3 to be wrong. And actually in this case, 1 and 2 are correct. So in the questions where 1, 2, 2, 3, 1, 3 are correct, try to see if you can disprove, or if you can disprove any of these 3 statements. Because if you disprove one, you will get the answer, even if you do not know about the other 2 statements. But if that question was only 1, only 2, only 3, then rather it was better meant to be skipped. How many statements are correct? Okay. Responsibility to protect was created by UN Department of Peace Operations. Another thing which I wanted to tell, whenever it comes about environmental initiatives or about the international programs, usually UPSC through its PYQ has given the body that was launched as wrong. So in this case, what is the body that is launched? UN Department of Peace Operations. Okay. India received this. No, this is part of current affairs we should have studied. R2P doctrine allows UN peacekeepers to use force to enforce political settlement. Look at this statement. It is a negative statement. We are talking about peace and we are using force for political settlement. We might use force to reduce war or to protect human rights, but not to enforce political settlement. So this is wrong. We do not have 1, 2, 2, 3 so that we directly get the answer. So this was wrong. And among these two, if we were to consider the body to be wrong, then we would have gone with 1 or 2. So in this case, the answer is 1. If this was 1, 2, 2, 3 and 1, 2, 3 sort of option, had we eliminated 3, we would have got the answer. Even here, NDB, EIIB, Asian Developmental Bank and African Developmental Bank, this is a part of a static, but I wanted to tell that international institutions are very important. If some country joins NDB, then that is in news, then we can expect a question. Be it NDB or be it any other international organizations like BRICS, BIMSTEC. So these are the things which we need to be aware, because these are asked recurrently in UPSC Prelims. Again the same thing here. In this question, we would have heard of PM Divine, development of northeastern region, or we could have heard about Act East Forum. Generally we are not aware of these two. So PM Divine, we know that PM Divine is development of northeastern region. So the main objective is not about organic value chain. So this we would have eliminated. Act East Forum, we know look east policy when we studied IR, and then we know that we made a transition to Act East policy. So that should somewhat be connected to connecting Northeast with the rest of Southeast Asia to promote development in Northeast region, such as through trade and so on. So promote regional tourism, we are talking about the main objective here. So we cannot take some very lower objective and bring it here. So promoting regional tourism, this would have been wrong, because it is only speaking of northeastern region and is not bringing into account the Southeast Asian regions. So if we knew this and this to be wrong, then we could have taken 50-50. Answer would be either only 1 or only 2. Because see, we cannot study each and everything. So in that case, it is highly likely that we wouldn't have come across those two options which are present in second and third statement. So there, when we get that 50-50, when we reduce it to 50-50, we are supposed to take a guess. Consider the following statements regarding PLFS. See, this is mains related thing. They can even ask in economy as to what are the changes that were made in PLFS 2025. So couple of things which I wanted to tell. It is a static syllabus, you can study it by yourself, but things that I wanted to tell is PLFS has improvised. Earlier only urban employment quarterly prospects were present. Now even in rural areas the employment prospects are present on a quarterly basis. Also monthly estimates of unemployment and employment indicators are given for both rural and urban. This is correct. Annual results are now reported based on calendar year, January to December. This is also another change. They changed the timeline of publishing it. And PLFS is now using districts as the primary geographical unit. This is also correct. Survey now excludes data of household income. See, another thing is here it is trying to be of more inclusive of rural areas along with urban. So it is trying to keep urban and rural at par. But look at here, the survey now excludes data from household income, from pension, rent, interest and remittance. Here it is trying to be more exclusive because it is not including the household income. So with time we get more inclusive, or we update our policy in such a way that it is more progressive. So in that sense also, if you had thought of, you could have thought that 4 is wrong, 1 is correct and 3 as correct. See, even here PLFS only covers urban areas for quarterly employment. If you had eliminated 4, you would have got B as wrong. If you had eliminated 5, you would have got 1, 2, 3 wrong. 1, 2, 3 as correct, even if you do not have much knowledge about it. This is another fact which I wanted you to know. Vizhinjam International Seaport. It is India's first deep water container transshipment port, because if you know, India was dependent upon other countries for transshipment. So in recent times, India has built this port. Also, one of the objectives, like I said, India's dependence on foreign transshipments, we wanted to reduce it, because we were dependent upon Singapore and Colombo. And what does transshipment mean? That is what is given in brief. So in this case, answer D is the right answer. See, 99 question, had we not known about this port, then we could have only said as 2 and 3 as correct. But had we known about this recent development, only then we could clearly answer it as D, or else we would be confused between C and D. Likewise, let us look at the last question with reference to District Mineral Foundation. See, this is a topic, static topic, which you need to study under MMDR Act, Mines and Minerals Act. And in this act, District Mineral Foundation non-profit statutory created under this, correct. Funds are contributed entirely from Consolidated Fund of India. No, this is wrong. So see, if they want to make it wrong, they'll give some extra word, entirely. So even if you did not know anything, but you went through that extra word, you would have considered this as wrong. State governments are empowered to prescribe the composition functions. See, here also it is looking generic. They could have made it look less generic by changing the word, such as state governments are the only authority to prescribe the composition. See, then it would look extreme, but they try to be generic. So 3 is correct, 2 is wrong, so answer becomes 1 and 3. So if I have to recap or give a brief summary over this paper, see, the paper is largely static. Please do not expect such questions to appear in the actual UPSC exam. I am not telling this thing to scare you, because this is level 1 question. We cannot give you the actual UPSC paper level of difficulty when you are beginning, because now you need to grow. You need to grow your confidence, because only when you grow your confidence will you be able to attempt more difficult questions in the future. So this was largely a static paper. Most of the questions that were asked were directly from your routine book, Lakshmikant. And in this paper, if you had scored more than 90 marks, then it would have been good. But if you had scored less than 70 marks, then there is nothing to worry. That means that you need to revise more and you need to get the concepts correct, because this is a static paper. Getting less than 70 is not appreciated, but still you have time to pull up your socks. But if you have got more than 90 marks or around 100 marks, then it means that you are on the right direction. I like to end this discussion. Thank you.